All right, folks, this is the first video in the series to help you file a divorce with children. All right, the first form we're going to fill out is the summons. It is the FL110, and it is up on the screen. If you can see the screen, that's great. If you can't, that's okay. Just follow along. I'm going to give the line number and tell you exactly where to fill things out. This is going to be a step-by-step tutorial on how to get this thing filled out. It's a very simple form. At the very top of the form, you'll see it says Summons Family Law, FL110 over on the top right corner. That way you know that you're dealing with the right form. All right. So on the left-hand side underneath Summons, it says Notice to Respondent. You should know right off the bat, if you file for divorce, you are the petitioner, and the party you are suing for divorce is the respondent. And it doesn't matter whether your case takes 3, 4, 5, or 10 years to finalize, you will always be the petitioner if you file for the divorce, and the other party will always be the respondent. And that's true even if you're filing a request for child support or spousal support 5 years down the road. You're still going to be the petitioner. And if the other party filed a request to modify child support or custody or visitation or something later, they would be filing the paperwork, but they still would be the respondent. Those names never change. All right. So right off the bat, off the top of the form, the FL110, underneath Summons, it says Notice to Respondent, name, and then you're going to put the other party's name in there. You should put at least, oh, by the way, it needs to be their correct legal name. If they're a junior, make sure you put junior. If they're the third, make sure you put, 3 ones afterwards, 3 I's to make it, John Doe the third or whatever it is. I would also recommend either using the middle name or at least the middle initial. Okay, so let's fill that out. On the top, you're going to put the other party's name. Couple lines down, it says petitioner's name is, and you're going to put your name in on that line. Again, make sure it's the correct legal name, and I would use at least the middle initial. All right, the next line is for the case number. You do not have a case number yet, so don't worry about putting in a case number. And by the way, sorry about beeping and clicking and phones ringing or whatever else you hear around here. We have an operating, ongoing law firm, so other people are doing real work behind me. Okay. Then there's a notice. You have 30 calendar days. That's a notice to the respondent. They have 30 calendar days to respond, blah, blah, blah. You can read that on your own. Okay, then in box number 1 toward the bottom of the form, you're going to put the name and address of the court that you are filing in. So keep in mind, you need to file in the court where you live or where the other party lives. So if you live in Orange County, you're going to file, there's only one place to file, you're going to file in Orange County. If you're in, oh, I'm noticing incorrect spelling here. Okay. If you are filing in Los Angeles County, you need to realize that you can file in Central, 111 North Hill Street, or you can file in many other districts, regional courts. You can look that up online. You can Google that and find out what family court. If you don't want to file in downtown Los Angeles, you can file in your local court, and you can Google where that is relative to your address. Okay, so you're going to fill in, number 1, you're going to fill the name of the court and the address of that court that you're filing in. And number 2 is real easy. That's your name, your address, and your telephone number. All right, that is all you need to fill out. The next line down, you can see where there's a date, a space for a date, and the space for the clerk's name to the right. You don't fill that out. The courts fill that out. Okay, that is that in complete. That's the complete form. That's all you need to know to get that thing filled out and filled out correctly. However, you should be aware that on page 2, and let me figure out how to get page 2 here. On page 2, you are going to see that there are 4 automatic temporary restraining orders that go into effect when you file a divorce or when you receive or get served divorce, and you should be aware of those. They're not the typical standard restraining order that we usually talk about, but there are 4 things that go into effect so that somebody doesn't cancel your insurance on you, or you don't, start liquidating all of the 401ks or pensions and start hiding all the assets. And they include, number 1, you are immediately, or the respondent is immediately restricted from and restrained from removing the minor children of the parties from the state of California without applying for an order for the court or getting written permission from the other party. So either you need a court order or written permission from the other side. An email, a text would suffice if you ended up in court to allow you to take the kid out of state or the children out of state. So make sure you don't mess that one up. You are also, number 2, restrained from cashing, borrowing against, canceling, transferring, disposing of, or changing the beneficiaries of any insurance policy or other coverage, including life insurance, health insurance, medical insurance, automobile insurance, disability, any kind of insurance, if that insurance is held for the benefit of the other party or your children. All right? Number 3, this protects assets. You are, when you file for divorce or when the respondent is served, you guys are restrained from transferring, encumbering, hypothecating, concealing, or in any way disposing of any property, real property or personal property, whether community property or even your separate property. Be careful, even your separate property, without the written consent of the other party or a court order. Now, there's an exception on this number 3, and that is except for in the normal course of business. What does that mean? Well, that means you can continue doing your banking, continue, if you're in a business, if you run a business where you sell cars, you can continue to sell cars. That's your business. Whatever your normal business practice is, you're allowed to continue doing that. If you normally trade and if you're a day trader, and you normally trade in stocks, you're allowed to continue doing that. But on that, I would be careful. If you're going to be doing extreme trades or selling off all the stock, you're probably going to run into problems doing that. So don't get into that trap. That is one of the exceptions. And a second exception is you're not allowed to sell things unless you need the money for the necessities of life. And so if you don't have any money to pay for food, you don't have any money for rent, you don't have any money to take care of your kids, you can sell something to pay for those necessities of life. They better be necessities of life, or you can get in trouble. Just as a bit of information, paying for your attorney or money to hire an attorney, the courts have determined that is a necessity of life. So if you need to sell something to hire an attorney, you are technically allowed to do that. Number 4, you are restrained from creating a non-probate transfer or modifying a non-probate transfer in a manner that affects the disposition of property subject to the transfer without the written consent of the other party or an order of the court before revocation of a non-probate transfer. An example of a non-probate transfer would be a trust, and there are other trust type documents out there. So let me finish this rule here, and then I'll tell you, ultimately the rule is make sure you go talk to an estate planner or an attorney before you do anything that might run afoul of this rule. Before revocation of a non-probate transfer, like a trust, can take effect, or a right of survivorship to property can be eliminated, notice of the change must be filed and served on the other party. Okay, so an example of a right, terminating a right of survivorship would be changing how your real property is held in title. If you have your property titled in joint tenancy, there's a right of survivorship, which means if you die, the property automatically goes to the other party. If you change that during a divorce without giving notice to the other party, you are going to have a problem. So there's a few things here, and it's kind of technical, but the long story short, all of these rules, 1 through 4, all of these restrictions and automatic temporary restraining orders, people call them ATROs, just in case you ever hear that. They are all designed for one thing: to keep the financial and property status, and the children status quo, until the court has time to make orders on custody visitation, how to divide assets, how to change who owns what, everything. So these rules are designed to keep everything the way it is until trial. So just wanted to give you an idea what those automatic temporary restraining orders, or ATROs, were about, because you're about to file for divorce and you're about to serve the other party, and you need to know what those are about. All right, folks, that's the entire summons, and the next video is going to pop up, and I hope that was of help. Thank you.